Uh-oh. Uh-oh. What do you see on your screen?
Are you speaking to us, Your Honor?
Yes.
I just see everyone's video.
Okay, super.
And at the top it says live on custom live streaming.
I see a YouTube page.
Are you speaking to us, Your Honor?
Yes. Yes.
I just see everyone's video.
Okay. Okay, super.
And at the top it says live on custom live streaming.
I see a YouTube page.
Are you speaking to us, Your Honor?
Yes. Yes.
I just see everyone's video.
Okay. Okay, super.
And at the top it says live on custom live streaming.
I see a YouTube page.
Are you speaking to us, Your Honor?
Yes. All right. I'm gonna stop that for a minute.
Okay.
I don't know what's going on. Okay. All right, that's better. I think. I'm gonna try that again. No, I think we're streaming now. Oh. Okay, so please raise your right hand. Please indicate by saying I do. If you swear to abide by the rule of this proceeding and conduct yourself in a manner that is honorable to this forum.
I do. I do.
Thank you. Now calling case number 082263, Cam Donaldson versus Karen Basha. Counsel for the plaintiff ready?
Yes, Your Honor, with housekeeping matters.
We're just ready in general. And counsel for the defense ready?
Yes, Your Honor.
All right. Housekeeping matters from the plaintiff prosecution.
Plaintiff, yes. May we presume that all objections are heard outside the presence of the jury, or would Your Honor like us to ask for a constructive sidebar before getting into any evidentiary arguments?
If you think the argument needs to be heard outside the jury, then you need to say, can we get a sidebar before that? And those sidebars will be constructive. If you don't say that, then I'll assume that you anticipated the argument to be in front of the jury.
Yes, Your Honor. We also anticipate calling an expert witness. Would Your Honor prefer we give a formal tender after laying the proper foundation, or should we just get straight into the expert's conclusions once the requirements of 702 are met?
I would like a formal tender, please.
Additionally, we'd like to bring to the court's attention that the local rules of this jurisdiction require that we provide copies of all exhibits to the witnesses prior to trial, as we may not share our screens until any evidence is admitted.
Okay, so noted.
And lastly, pursuant to local rules, my co-counsel and I will be using a dual camera setup for our statements, direct examinations, and cross-examinations. We wanted to let you know in advance so you were not surprised or confused when we do so.
Okay, well done.
And that's all we have.
All right, any housekeeping from the defense?
Yes, Your Honor. Your Honor, it is our understanding that the federal rules of evidence as well as the federal rules of civil procedure apply to today's case.
That's correct.
Your Honor, that is our only preliminary matter. We are ready to proceed into motions in limine.
All right. Plaintiff, do you have any motions in limine?
Yes, Your Honor, we have three. First, this case is about the defendant causing the wrongful death of Lou Donaldson and fraudulently changing his will to inherit all of his property and assets. The plaintiff moves at this time to admit Lou Donaldson's last will and testament, which can be found on page 53 of the record, and it's bait stamped 0014. Would Your Honor like me to state the grounds of admissibility?
I will, are you trying to pre-admit this?
Yes, Your Honor.
What are you trying to do?
Pre-admit it, Your Honor.
Okay. For what purpose? Why you need to pre-admit it? Why can't we just admit it during the trial?
Just to move things along in a more fluid manner and just to make sure that we have everything to begin with.
Any objection from the defense to pre-admit the last will and testimony?
No, Your Honor.
All right, hearing no objection, then I will allow that that's admitted without any foundation being laid.
Yes, Your Honor. Will that be Plaintiff's Exhibit 1 then?
Sure.
Yes, Your Honor. Our second motion is one of the other elements of today's case is that the plaintiff must prove that Lou Donaldson is in fact dead. Mr. Donaldson's bank account and assets have not been used since his passing, and the plaintiff moves to admit the documents on page 54 of the record. That's Bates stamp 0015, Lou Donaldson's bank statement, into evidence as Plaintiff's Exhibit 2.
Any objection to pre-admitting the bank account statement?
No, Your Honor. No objection to that either.
All right. Then it is admitted without any foundation.
Yes, Your Honor. Now my co-counsel will handle the third motion in limine.
We'll call that Plaintiff's Exhibit 2. And your third motion in limine.
Yes, Your Honor. The plaintiff also moves to admit a portion of the video created by Exotic Bob and its transcript found on page 30 of the record into evidence as Plaintiff's Exhibit 3, starting at 40 seconds, full paragraph 4, the paragraph starting with UC, and ending at 1 minute 45 seconds, full paragraph 6 in the transcript.
Okay, so you want to offer a portion of the video?
Yes, Your Honor, and the transcript, the corresponding transcript into evidence.
Any objection to pre-admitting that?
Yes, Your Honor. We object to 403 for unfair prejudice against the defendant. I mean, it also depends on which portions of the transcript. If I'm correct, I believe it's from, you see, it was 2 years ago, all the way to the end of, and that's all I have to say about that. Is that correct?
Yes, those are the only portions that would be entered.
Yes, Your Honor. We object to the admitting of this evidence pursuant to, first and foremost, hearsay, and also under Federal Rule of Evidence 403, that this would, the probative value of this evidence is substantially outweighed by the danger of unfair prejudice against the defendant in this case.
Okay. Plaintiff, what's your response to the hearsay objection?
According to stipulation 4, Exotic Bob is an unavailable witness pursuant to 804A. Additionally, in this video, Exotic Bob states that Karen Baja, the defendant, threatened to kill Exotic Bob in the same way she killed her husband. This is an admission of guilt or liability that falls within the party opponent exclusion from hearsay 801 D2A. The second layer of hearsay is remedied pursuant to 804B as a statement against Exotic Bob's penal interest.
Any response to that, defense?
Your Honor, these statements are being used for the truth of the matter asserted in the statements. Therefore, they would still fall under the hearsay. And I reassert our 403 objection that this would be the danger of unfair prejudice and misleading the jury to think that because she said these statements, or this person's claiming that she said these statements, that she must have acted in accordance with it in today's case. So for those reasons, we ask that you deny the plaintiff's motion.
Okay, I'm gonna allow the video to be played and pre-admitted. I agree with plaintiff's counsel regarding the hearsay issue, and I don't think it's unfairly prejudicial under 401(3).
Your Honor, can I get a point of clarification? So is the only portion that's admitted is those two paragraphs, or are we allowed to read in another portion of the transcript during when they admit this evidence?
I think for the rule of completeness would allow you to offer any other portions that you deem pertinent. So I would say the entire video is going to be admissible. and you can just play portions, whatever portions that you'd like to play.
The plaintiff has no other motions.
Defense, do you have any motions in limine?
Yes, Your Honor, we have one motion in limine for you to hear, and one stipulation that opposing counsel and I have discussed prior to trial. Which would you?
Okay. The motion first, please.
Your Honor, the defense moves to exclude any and all mention of the request for temporary restraining order filed by Lou Donaldson in today's case. By way of context, Your Honor, the defendant in today's case was Lou Donaldson's wife, and he filed a request for restraining order against her. Pursuant to Federal Rules of Evidence 403 and 805, this should be excluded. First and foremost, this document is hearsay within hearsay. And second, Your Honor, any probative value that the request for temporary restraining order has is substantially outweighed by the danger of unfair prejudice and confusing the issues to the jury today. This court actually denied this motion, and the defendant has denied all allegations contained therein. So we ask that you exclude any and all mentions of the request for temporary restraining order.
Any objection to this motion?
Yes, Your Honor. We intend to offer the application for a temporary restraining order. Would you like my response to the 403 argument or the hearsay argument first?
Either one.
For the hearsay argument, first, this was an application for a temporary restraining order that was filed with a court in this jurisdiction. Therefore, Your Honor may take judicial notice of this document. In the alternative, it falls under the exception to hearsay 8033, as they are statements of Lou Donaldson's belief at the time that he submitted this application.
Do you have a witness that can authenticate the document?
Yes, Your Honor. The son of the deceased, Lou Donaldson, Cam Donaldson is the son, I apologize, has personal knowledge of this document, its filing, and will be able to lay the sufficient foundation in order to admit it.
And I believe the 403 issue?
For the 403 issue, Your Honor, this document is not substantially more prejudicial than it is probative. It is one of the elements of today's case that the plaintiff must prove that the defendant did in fact cause the death of Lou Donaldson. His belief that the statements contained therein, the statement that Karen Baja had threatened to kill him, is very probative to that element, as it goes to her intent and his fear and his fear of her at that time.
Your Honor,
Yes, go ahead.
Your Honor, there is the probative value of this request for restraining order is substantially outweighed by the danger of unfair prejudice. If the jury is to hear the information and the statements contained therein, which the court actually denied this request, they will unfairly make improper inferences based on the statements therein and not decide the case on its merits today.
What improper inferences are you afraid of?
Well, Your Honor, we don't know the truth to these statements and where they. We know that Lou Donaldson filed them, but we don't know the truth behind them. And Your Honor, if they hear these statements, just the statements alone will be unfairly prejudicial to the defendant.
Okay, I'm going to grant the motion in part. I'm going to grant a limiting use that this can only be shown for the limited purpose that Donaldson was afraid of the defendant. And that's the only use, but I'm not persuaded by these arguments to exclude it completely. So I will allow it for that limited purpose.
Yes, Your Honor.
Okay. What is your stipulation that you have? That you, I guess, a new stipulation you've agreed to?
Opposing counsel and I have stipulated that there will be no introduction of or mention of a polygraph test or the defendant's refusal to take a polygraph test.
Is this correct, Mr. Counsel?
Yes, Your Honor.
All right. Any other motions before we begin?
Your Honor, at this time, the defense is ready to move to opening statements.
All right. Okay. So we are prepared for opening statements. Plaintiff, you may begin.
Your Honor, may I have a brief moment to set up?
You may.
Thank you. May I proceed, Your Honor?
You may.
A man disappears without a trace under mysterious circumstances. It seems like it could have been anything. It seems like it could have been one of those unsolvable mysteries. But things get a lot clearer when you realize the timeline tells it all. Let's rewind to a little bit over a month before Lou Donaldson disappears. Lou and the defendant are fighting again. Lou tells the defendant that he wants a divorce. Days later, Lou runs down to the courthouse to get a temporary restraining order because he believed that he needed to be protected from the defendant.
Objection, Your Honor.
What's the objection?
The approach, you just kept out the request for a restraining order and said it could only be used for they were afraid.
May I be heard, Your Honor?
You may.
My specific statement was
Outside the
that,
presence of the jury.
yes, Your Honor. My specific statement was that he believed that he needed to be protected. It was strictly for the intent. I'm sorry, it was strictly for his state of mind.
Okay, I'm going to overrule and allow him to continue.
Days later, Lou Donaldson runs to the nearest courthouse to get a temporary restraining order because he believed that he needed to be protected from the defendant. And then he tells her that he wants a divorce again. They fight again. 2 weeks from that second fight is the last time Lou Donaldson is seen alive. 5 years to the day of his disappearance, the defendant cashes in and collects all of Lou Donaldson's property, the first opportunity she gets. Suddenly, Lou Donaldson's unsolvable disappearance points directly to the defendant. Today, we will prove to you by a preponderance of the evidence that Karen Baja intentionally or recklessly caused the wrongful death of Lou Donaldson. But to do that, we're going to have to take you back a little bit farther. We're going to have to go back about 20 years. The defendant is walking down the side of a road late at night. She has no money, no car, no family, nowhere to go. And that's where Lou Donaldson sees her for the first time. Fully invested in this new romantic venture, Lou divorces his first wife, but he continues to maintain an amicable relationship with his first family. He even brings his son on as his personal assistant. Fast forward a year or so. Lou Donaldson and the defendant get married. Suddenly, she has a house, she has a car, she has money, she has a husband, she even has a big cat sanctuary that's become her main focus. But things didn't stay great forever. About 11 years into their marriage, things began to sour. You'll see that it all comes to a head when Lou asks the defendant for a divorce, but gets a terrifying response. Out of fear for his life and his safety, Lou applies for a temporary restraining order. You'll see that temporary restraining order application. You'll see that Lou was scared to death of what the defendant was capable of. And you'll learn that the court mistakenly rejects this application, not realizing that those threats were guaranteed. It's now August. And Lou still wants out. But before he could do that, he just disappears. But members of the jury, people don't just disappear. Statesville is not the Bermuda Triangle. Instead, you'll see that what we have here is a defendant who was afraid of losing everything her husband gave her. So how does she stop that from happening? Well, simply, she just stops him from leaving. You see, dead men can't walk out, and she knew that. On August 18th, 2012, Karen Baja murdered Lou Donaldson. But she couldn't do it alone, and she needed an alibi. So she killed 2 birds with 1 meat grinder. In the early morning hours of August 18th, the defendant met up with her brother. And as the evidence will show you, that's when they carried out their plan to get rid of Lou. But she also needed to make sure that she wouldn't have to live without his money, without his property, and without those big cats that she was so obsessed with. So today, you'll hear from Taylor Pride, an expert in forensic documents and handwriting analysis. Taylor Pride will tell you about how the defendant failed to forge Lou Donaldson's signature. She'll show you how the defendant failed to sign Lou's name before she broke into the office and stole the original will from Wild Wildlife. You'll even hear from Cam Donaldson, Lou's son. He'll tell you about how the defendant broke into the office and stole the will before anyone besides her even knew that Lou had gone missing. Now, before I finish up, I just want to remind you all of something. You were chosen to be on this jury because you took an oath to uphold justice. And that is exactly what my co-counsel will do at the end of today's trial. When she comes up here and she presents all the evidence you've seen and the testimony you've heard, we are confident that you'll know that justice is a verdict of liable. Your Honor, you're muted.
Apologize. Thank you, Mr. Lemay. Mr. Troutman, are you ready for your opening statement?
Yes, Your Honor. May it please the court?
Yes.
Opposing counsel, members of the jury. Sometimes the simplest explanation is the only explanation. The more complex a theory is, the less likely it is to be true. The more details, the less probability of accuracy. Members of the jury, what's more likely? That's what today's case is about. Throughout today's trial, I want you to keep 2 questions in mind. Is it more likely that the defendant concocted an elaborate plan 16 years in the making to kill her husband and take everything he owned? Or is it more likely that the defendant didn't kill her husband? To understand why the simplest explanation is the only explanation, we need to go back to when Karen Baja met her husband, Lou Donaldson. You see, the two met almost 2 decades ago. And at first, my client thought she had met her Prince Charming, her soulmate. In the years after they were married, they ran Wild Wildlife, a big cat sanctuary, together. But just like many other marriages, their marriage had some hiccups. You see, the defendant was aware that her husband would take off at a moment's notice in one of his many planes, but she later found out he was being unfaithful. He was flying off to be in the arms of another woman in Costa Rica. But despite that, Ms. Baja was loyal to her husband. She wanted to stay with him, and she thought he did too. On August 17, 2012, Mr. Donaldson was seen for the last time leaving Wild Wildlife. After that, he vanished. He was gone. The members of the jury, you're going to learn what everyone in this courtroom knows. And that is, no one knows where Mr. Donaldson is. Not the plaintiff, not the sheriff's office, and certainly not the defendant. The plaintiff is going to bring you a hired investigator today, and their investigator is certain about their conclusions. But you're going to learn that their investigator wasn't hired until almost 5 years after Mr. Donaldson's disappearance. Their investigator is going to take the stand and tell you that the sheriff's office didn't do their job, that they didn't investigate properly. The members of the jury, that investigation isn't finished. It's still ongoing. And I want you to pay extremely close attention to what the sheriff's office did tell their investigator, because you're going to hear today, the sheriff's office hasn't found any evidence of foul play, and they haven't charged my client of anything. So in essence, at the end of today's trial, the plaintiff is going to ask you to decide what happened to Mr. Donaldson in one day, when the sheriff's office hasn't been able to make a decision in over 8 years. Not only that, but you're going to learn that their investigator explored the possibility that Mr. Donaldson flew off to the other woman in Costa Rica. And to do that, their investigator sent a grand total of one person. One person to search the entire country of Costa Rica for a man who, if he is there, wouldn't want to be found. Now we're going to bring you Chris Renard, an insurance company investigator and document examiner. You see, Mr. Renard isn't being paid by either side sitting here today. He's worked for Summit Life Insurance for 20 years. And he was asked by the CEO of his company to investigate the $5 million life insurance payout to the defendant. Now, he was specifically asked to look into whether or not the defendant killed her husband and whether or not the defendant forged her husband's will. But despite having 5 million reasons to want to stop the payment, Mr. Renard's going to tell you today, Summit Life Insurance had no way of pointing the finger at the defendant. There just wasn't enough evidence. So that brings us to the burden today. The plaintiff has brought this claim to you all, so they carry the burden that comes with it. They must prove to you all that what they say actually happened. My client, on the other hand, has nothing to prove. She hasn't blamed a single person for what's happened because she's going to tell you herself she doesn't know what happened. This time, members of the jury, you'll learn the simplest explanation is the only explanation. Miss Baja did not cause the death of her husband. At the end of today's trial, my co-counsel, Miss Mathier, she's going to speak to you. And when she's done, all you're going to be left with is unanswered questions, just like the defendant was. And that's why you will have to return a verdict finding the defendant, Miss Baja, not liable.
Your Honor, I think you're on mute.
Thank you, Mr. Troutman. Thank you, Ms. Riegelberger. Plaintiff, call your first witness.
The plaintiff calls Cam Donaldson to the stand.
Cam Donaldson, you are pre-sworn. So you may proceed.
Please introduce yourself to the jury.
My name is Cam Donaldson, and I live here in Statesville.
Where was your most recent employment?
I was employed by my father at Wild Wildlife for the last almost 20 years as his personal assistant.
What is Wild Wildlife?
Wild Wildlife Big Cat Emporium is a refuge and sanctuary for big cats like lions, tigers, and leopards. And it was always my father's dream to open up a refuge to take care of these big cats.
I'd like to talk to you more about your father. Who is he?
My father was Lou Donaldson, and unfortunately, he's no longer with us.
Please describe for the jury the last time you saw your father.
Saw him about 8 years ago.
Describe your father for the jury, please.
He was a free spirit, someone who had big ideas. He was a self-made man, though. He had very little education and worked hard to get where he was.
Tell us more about working with your father.
My father was the one with the vision, but I made the trains run on time. It was good working with him. Even, you know, he was always very consistent with me. Whenever he went somewhere and had to go on a trip, he would tell me when he was going to leave and when he would be back.
Please describe for the jury your personal relationship with your father.
We loved each other, and working together was a great opportunity. We got to see each other every day, and we kept a weekly Sunday dinner that we would see each other. And we were different for sure, but we loved each other a lot.
Mr. Donaldson, now I'd like to ask you some questions about how you lost your father. Please tell the jury when that happened.
About 8 years ago, we lost him.
When was the last time you saw your father?
So on August 17th, 2012, at about 6 p.m., he was leaving Wild Wildlife for the week, and he said that he would see me on Monday unless...
May I be heard? Your Honor, sorry.
What's your objection?
Your Honor, I'm sorry, may we approach first? Sorry.
Okay, we'll do this constructively outside the presence of the jury.
Yes, Your Honor. Your Honor, I objected to hearsay. If this witness testifies in accordance with his deposition, it is our understanding that he will say that his father told him information that he would see him on Sunday for supper, and that is hearsay. It is out of court statement being used for the truth of the matter.
Response?
Yes, Your Honor. Pursuant to Federal Rule of Evidence 8033, this falls under the exception to hearsay as intent or plan.
Okay, I agree. Overruled. The jury is reconvened.
Mr. Donaldson, please describe the last time you saw your father.
On August 17th, 2012, at about 6 p.m. at Wild Wildlife, he was leaving for the week, and he said that he would see me on Sunday for our family dinner weekly. Otherwise, if I didn't make it, that he would see me on Monday for work. And I didn't make it on Sunday for dinner, and so I never saw him again.
Since that day, when you last saw your father, what contact have you had with him, if any?
None. No calls, no texts, no emails, no snail mail, nothing.
I'd like to direct your attention now to what has happened since your father's disappearance. Specifically, what has happened to Wild Wildlife?
Karen has taken it over after she put together this fraudulent will.
Directing court and counsel to what has been admitted into evidence as Plaintiff's Exhibit 1, the last will and testament of Lou Donaldson. Publishing for the jury, Your Honor?
You may.
Mr. Donaldson, do you recognize this document?
Yes, I do.
What is this document?
This is what Karen is claiming is my father's last will and testament.
Please describe for the jury what is written in this will.
This will left my father's assets to Karen alone if he should, quote, die or disappear.
Now, you said that this is what the defendant is claiming is your father's will. What do you mean by claiming?
My father had another will. It wasn't this one.
Objection, Your Honor. Best evidence rule. May I approach?
So sidebar, we'll do this outside the presence of the jury. What is your objection?
Your Honor, I'm objecting to the best evidence rule. This witness just testified that there is a different will, and that will is not present today in court, and it would be more beneficial to see that other will that he claims exists, and we do not have that will, so this is a violation of the best evidence rule.
May it be heard, Your Honor?
You may.
Opposing counsel's objection is untimely, as the witness's testimony was just that there's an existence of the will, and he is not at this time testifying to any of its contents.
Your Honor, may I be heard?
Yeah, I think she's objecting to not the contents, but the existence. Is that correct? Is that a fair assessment, Ms. Mateer?
Yes, Your Honor. I'm objecting to that there's an existence of a different will. Yes, Your Honor.
Okay. What's your response to that, Ms. Riegelsberger?
Your Honor, if I may proffer, the witness will lay the proper foundation for the exception to the best evidence rule pursuant to Federal Rule of Evidence 1004C. This exception lays the states that if the original is in the possession of the party opponent, then the alternative testimony may be given to its contents and existence.
Okay, is that true? Are you in possession of this document, Ms. Mateer?
Your Honor, we're not in possession of any other alleged will. There's no other alleged. There's just an allegation that there's another will, but there's no proof that there is another will.
May I be heard, Your Honor?
So it's my understanding it's disappeared then. Who was responsible for its disappearance?
This witness will testify that the defendant is responsible for its disappearance.
Do you agree with that, Ms. Mateer?
Yes, Your Honor, this witness and this witness alone will say that the defendant is responsible for his disappearance. However, there is no other information to support that claim.
May I be heard, Your Honor?
No, I'm going to rule. I'm going to allow the testimony. So he may testify to it.
Yes.
You may proceed.
Mr. Donaldson, you said that you were claiming that the defendant is claiming this is your father's last will and testament. Why do you say claiming?
Because my father had another will and it wasn't this one.
To your knowledge, when did your father tell you he was replacing his original will?
He didn't.
Where was that original will kept while your father was still alive?
I kept it in a lockbox in the bottom right drawer of my desk at Wild Wildlife, under lock and key.
Where is this will now?
Karen has it.
When did she take it from your desk?
On August 19th, 2012, just 2 days after I saw my father last.
What happened that morning?
Started about 6 a.m. An alarm went off at Wild Wildlife, and so I immediately went to the office.
Directing court and counsel to pages 28 and 29 in the record, what has been bait stamped marked as 004 and 005. Marking for identification as plaintiffs exhibit 4 and 5, I believe. Mr. Donaldson, do you have these documents in front of you?
Yes, I do.
Do you recognize these documents?
Yes, I do.
How do you recognize them?
Because they're photographs of what I took of the gate and padlock when I arrived on the scene.
What do you recognize these documents to be?
They are a photo of the gate that was broken and the padlock that was cut when I arrived on August 19th, 2012 to Wild Wildlife after the alarm went off.
Are these photographs fair and accurate representations of what you saw when you arrived at Wild Wildlife on the morning of August 19th, 2012?
Yes, they are.
Plaintiff offers into evidence what has been marked as Plaintiff's Exhibit 4 and 5.
Any objection to these, Ms. Mateer?
No objection, Your Honor.
All right, hearing no objection, so entered.
Mr. Donaldson, please describe for the jury exactly what you saw when you arrived at Wild Wildlife on the morning of August 19th.
When I arrived that morning, a little after 6 a.m., I saw the gate had been busted up like this. And then on the ground, I saw that padlock that, just as it is in the picture, had been clearly cut through.
What did you do after you found the padlock, the cut through padlock?
I went straight to the office. And as I got there, Karen was coming out. She had the will in her hand, and there was someone else with her. and that gentleman had a lock cutter.
What happened when you saw the defendant holding the lockbox that contained your father's will?
I'll never forget it. She looked right at me. We made eye contact and she just smirked.
What happened after the defendant smirked at you?
Well, the police had arrived since the alarm went off, and they tried to ask her some questions, but she said that she kind of laughed and said she was the owner of Wild Wildlife.
What was your reaction to the defendant's statement to the police?
I was totally confused. This was only 2 days after I had last seen my father alive, and Karen was the only one claiming that he had disappeared.
Were you still working at Wild Wildlife when this break-in occurred?
Yes, I was.
Why do you not work there anymore?
Karen fired me on August 20th, 2012, the very next day.
To your knowledge, Mr. Donaldson, who was supposed to inherit your father's estate according to his original will?
His assets were supposed to be divided 4 ways. A quarter was to go to my mother, a quarter was to go to me, a quarter was to go to a foundation that would allow Wild Wildlife to continue, and then a quarter was to go to Karen.
I'd like to talk more about your father's finances. Other than Wild Wildlife, what did his estate consist of, if anything?
A $5 million life insurance policy.
Who was the beneficiary of that policy?
Karen, she got all of it.
When did this occur?
As soon as she could, 5 years to the day, she filed the claim and got the $5 million.
I'd like to talk more about the defendant. Please describe for the jury your relationship with the defendant.
It's no secret that I don't like Karen. She stole my father away from my mother. But to be honest, she didn't really treat my father all that well when he was alive.
Based on your own observations, how did the defendant treat your father?
I specifically remember 2 huge fights they had that started about 2 months before he disappeared.
What happened during the first of these fights?
My father said that he wanted a divorce.
Objection, Your Honor. Hearsay. May I approach?
All right, it's taken outside the presence of the jury. What is your objection?
Your Honor, if this witness is allowed to testify and testify in accordance to their deposition, we anticipate that they will say that Mr. Donaldson told Ms. Baja that he wanted a divorce. This is an out-of-state courtment being used for the truth of the matter asserted and should not be heard by the jury.
Response?
Yes, Your Honor. Pursuant to Federal Rule of Evidence 8033, this is a statement of intent and plan. In the alternative, the statement goes to the effect on the listener, the effect being not only Cam Donaldson, but also the defendant.
Well, Mr. Dawson, were you there when the statement was made?
Yes, I was, Your Honor.
I'm going to overrule the objection.
Yes, Your Honor.
What happened during the first of these fights?
My father told her that he wanted a divorce, and she screamed at him that she was going to kill him.
What did your father do after the defendant threatened to kill him?
My father filed for a temporary restraining order.
Directing court and counsel to page 55 of the record, what has been bait stamp marked as 0016. Marking for identification as Plaintiff's Exhibit 6. Mr. Donaldson, do you have this document in front of you?
Yes.
Do you recognize it?
Yes, I do.
How do you recognize it?
I have seen it before.
What do you recognize it to be?
It's the temporary restraining order that my father filed against Karen Baja.
Is this document in a fair and accurate, is this document in the same or substantially the same condition as the last time you saw it?
Yes, it is.
Plaintiff offers what has been marked for identification as Plaintiff's Exhibit 6 into evidence.
Any objection other than what we talked about pre-trial?
No, Your Honor, we would just like to renew our objection made during motions eliminating.
Okay. I believe we discussed this, that we would offer this just for a limited purpose. And so just make sure that you keep that limited purpose in mind.
Yes.
All right, so hearing that, it is entered for the limited purpose of showing her or his fear.
Mr. Donaldson, what were the reasons that your father gave for filing this application?
Your Honor, I think your witness's mic is off. It's on mute. Sorry.
My apologies.
Yeah.
Thank you. Thank you. Karen Baja has threatened to kill me. I am seeking a divorce from Karen Baja. I do not feel safe around Karen Baja.
Okay. We will exclude the divorce comment. The jury will disregard that comment. We'll stick with only the fear.
Yes, Your Honor. Mr. Donaldson, I'd like to direct your attention to the second fight that you mentioned. What happened during that second fight?
I overheard them arguing at Wild Wildlife. My father told her that he was in fact filing for a divorce.
Objection, Your Honor. Hearsay. This may we approach?
I don't think there's any need to approach. You've made the objection in open court. What's your response?
Your Honor, again, this falls under the exception to hearsay 8033 as intent.
Okay, I'll allow it. Overrule.
Mr. Donaldson, what did you observe during this second fight?
I heard them arguing at Wild Wildlife very loudly. My father said that he was going to file for a divorce and she stormed out of the room.
What did you see and hear after the defendant stormed out of your father's office?
My father followed. He looked visibly shaken. And he said to me, if anything ever happens to me, have the police
Objection,
look in.
Your Honor. May I approach?
You may.
Your Honor, if permitted to testify in accordance with his deposition, we anticipate that this witness is going to restate a statement made by his father. This is an out-of-court statement being used for the truth of the matter asserted and should not be heard by the members of the jury.
Response?
May be heard.
Mhm.
Pursuant to Federal Rule of Evidence 8032, the statement falls under the excited utterance exception to hearsay. The witness has laid proper foundation that his father was in a heated argument so loud that he could hear it through the closed door. Immediately after the defendant stormed out of the office, his father also came out of the office and made this statement while still under the excitement of that fight.
Okay, I'm going to sustain the objection. I don't believe it's an excited utterance. So you will proceed.
Yes, Your Honor. Mr. Donaldson, how did your father appear when he left the fight with the defendant?
He looked visibly shaken.
How soon after this fight did your father go missing?
He disappeared 2 weeks later.
No further questions at this time.
Cross-examination.
Yes, Your Honor. May I inquire?
You may.
Good afternoon, Mr. Donaldson. I'm going to ask you a few questions about what you discussed during the direct examination. You and your dad were close, right?
We were.
But you didn't know that your father was having an affair, did you?
I did not.
And you also didn't know how many planes your father owned, do you?
No, I did not.
And Mr. Donaldson, you didn't know that your father was flying his planes in order to go see his mistress in Costa Rica, did you?
No.
Now, your father, he never properly registered his planes, did he?
No.
And sometimes he would even fly without logging a flight plan.
Yes.
And actually, about a few months before your father went missing, his pilot license was suspended, correct?
Correct.
But he continued to fly his planes.
Yes, he did.
Now, it's your belief or your position that your father never flew out of the airstrip where the van was found, right?
Yes.
But we can agree that it was your father's van that was found at the airstrip.
Yes.
And inside of that van, your father's glasses were found, right?
Yes.
And his keys.
Yes.
Now, let's move on to your father's will. It's your position that Miss Baja forged your father's will, correct?
Correct.
And you think that there was another will, right?
Correct.
But you don't have a copy of that other will.
I do not.
And you believe that the will that Ms. Baja has is fake.
Yes, I do.
But you weren't there when it was signed, though.
No.
You actually hired a forgery expert to investigate that will.
Yes, I did.
You paid that expert with your own money.
Yes.
And we can agree that you told that expert that, or you told that investigator that you thought that Ms. Baja killed your father.
Objection. Calls for hearsay.
Your Honor, may we approach? Your
Your Honor,
Honor,
I believe you're muted.
We're at a sidebar.
Your Honor, this is a statement made by the opposing party, in this case, the plaintiff. And therefore, it does not fall under hearsay, Your Honor.
What is the statement what was the question?
I asked this witness if they told the investigator that they hired that Ms. Baja killed their father.
So it's the statement from Mr. Donaldson.
Yes, Your Honor. It's from Mr. Donaldson to the investigator.
Okay. And your response to the hearsay objection?
No other response. No other
I'm
response,
sorry,
Your Honor, on
Ms.
those grounds.
McKeer, I'm trying to understand your response to her hearsay objection.
Sorry, Your Honor. I was saying that this is a statement made by the opposing party, and therefore it is not hearsay.
Okay, but you're saying the statement is made by Cam Donaldson.
Yes, and that would be the opposing party to the defendant, Ms. Baja.
Okay. I'll allow it. Go ahead.
Yes, Your Honor. Now, Mr. Donaldson, I'm going to ask you that again. We can agree that you told this investigator that you thought Ms. Baja killed your father, correct?
Correct.
Now, let's talk about what happened after your father's disappearance. Ms. Baja took over Wild Wild Life.
Yes, she did.
And she inherited your father's estate.
Yes, she did.
She also inherited your father's insurance benefits.
Yes, she did.
But you actually didn't inherit anything, did you?
No, I did not.
And your father, he disappeared in 2012, correct?
Correct.
But Ms. Baja, she received those benefits in 2017.
Correct.
And you didn't pursue any legal action until after she received those benefits, right?
Yes.
And just to be clear, that was about 5 years after your father disappeared.
Yes.
Now, Mr. Donaldson, let's discuss that restraining order that you mentioned earlier. The court actually denied that restraining order, correct?
Correct.
And they denied it because they said that they didn't find any credible evidence of an actual threat of bodily harm, right?
Objection, hearsay.
I'll sustain that objection.
Move to strike.
Your Honor, may I be heard? I'm sorry, Your Honor.
Well, the jury heard that the application was denied, so that should be sufficient.
Yes.
Move to strike the rest of the question, Your Honor.
Jury will disregard the rest of the question.
Your Honor, may I continue?
You may.
Mr. Donaldson, it's your position that your father was killed.
Yes.
And you believe that your stepmother was responsible.
I do.
But to be clear, there have been no remains of your father ever found, right?
Yes.
Your Honor, a moment to confer.
Sure.
No further questions.
All right, any redirect to this witness?
Yes, Your Honor. Mr. Donaldson, you were asked some questions on cross-examination about your father's glasses that were found in his van. How bad was your father's eyesight?
He was blind as a bat. It was bad. He wouldn't go anywhere without those glasses.
You were also asked some questions on cross-examination about your father's flying habits. What would your father do before he took any trip?
Even when he didn't log his flights with the proper authorities, he always told me the details because I was his personal assistant. So he would tell me where he was going, when he was leaving, what airstrip he was leaving from, and when he would return. It was critical for our business.
Thank you. No further questions.
All right, this witness is excused. Call your next witness.
Yes, Your Honor. Plaintiff calls Taylor Pride to the stand. Your Honor, before I proceed, may I ask the court's permission to remain seated during my direct examination?
As you wish, yes.
Yes, Your Honor. May I proceed at this time?
You may.
Good evening. Could you please introduce yourself to the jury?
Hi, my name is Taylor Pride.
What do you do for a living, Ms. Pride?
I have my own private investigation firm called Pride Investigations.
How are you connected with today's case?
Cam Donaldson brought me on in 2017 to investigate and provide an expert opinion about the will, and I've been working on it since then.
I want to talk to you a little bit about your background. How long have you been a private investigator?
Since 2016, so about 4 years now.
What did you do before then?
Well, I started my career with the Pioneer Police Department in 1998 as a patrol officer. And then in 2000, I became a detective, and I worked there until 2016.
What exactly did you do at the Pioneer Police Department?
Well, I did all sorts of things, but from 2002 to 2008, so for a good chunk of my time there, I was on the economic crime unit, but I've done everything from fraud to murder.
And what do you do nowadays as a private investigator?
Once again, everything, all sorts of things, from surveillance to missing persons, but my specialty is handwriting analysis and forensic document analysis.
What is forensic document analysis?
Forensic document analysis is basically looking at a document and then all of its content. So that's going to include things like handwriting, signatures, language and word choice, history, to try and figure out its origin and if it's been altered or modified in any way.
Have you received any sort of special training?
Yes, I have.
Please tell us about that.
Well, I attended an extensive 2-week seminar that was hosted by the American Association of Handwriting. And then I've also have been certified by the American Board of Forensic Document Examiners.
Just 1 second. What's the American Association of Handwriting Analysis?
It's actually the premier, I think.
Objection, Your Honor. Your Honor, this is improper bolstering by this witness. If this witness is allowed to testify, they're going to say that the organization that they were certified for or by is the premier organization, and this is outside the scope of their expertise. It's improper bolstering.
I'm going to overrule that.
Let me ask you again, Ms. Pride. What is the American Association of Handwriting Analysis?
It's the premier document examination organization in the country.
What's the American Board of Forensic Document Examiners?
It's a board that gives out certificates kind of showing that you have knowledge in the subject. So I'd compare it to the bar for lawyers or the boards for doctors. So it's just kind of showing that you've completed the certification, you have knowledge.
How does one get certified by the American Board of Forensic Document Examiners?
Well, you have to attend an extensive 2-week seminar, as I mentioned before. And then in addition to this, you have to submit your credentials. You have to take a pretty lengthy multiple choice exam, do a practical case assignment, and then submit to an oral board.
Ms. Pride, have you maintained your certification with the ABFDE?
Yes, I have.
How have you maintained your certification?
Well, I get recertified every 4 years. And then in addition to that, just obviously continuing practicing at my private investigation firm. Additionally, I attend annual 8-hour courses and just keeping up with current literature, studies, books, things like that.
Let's talk a little bit about your preparation for today's case. What documents did you rely on in coming to your opinion?
I reviewed all the documents submitted to me by Summit Insurance, specifically the will, the application for a temporary restraining order, and then Christopher Nart's report.
Would other experts in your field rely on the same documents?
Yes, they would.
Did you apply reliable principles and methods in coming to your conclusions today?
Yes, they did.
Were you able to come to a conclusion within a reasonable degree of professional certainty?
Yes, I was.
Your Honor, pursuant to Federal Rule of Evidence 702 and the witness's testimony, the plaintiff offers Ms. Pride as an expert in forensic document and handwriting analysis.
Any objection to that?
No objections, Your Honor.
All right, the witness may so testify.
Ms. Pride, you mentioned before that you arrived at an opinion on today's case, specifically about Lou Donaldson's will. What was that opinion?
It is my professional opinion that the signature on the will purporting to be Lou Donaldson is in fact a forgery. I also believe that the entire will is likely fraudulent based off of its highly unorthodox language.
Now, before we get into the specifics of the will, how, if at all, did you address the Costa Rica theory that was put forth by the defense in opening statements?
I sent someone down to Costa Rica to try and find Mr. Donaldson, but they couldn't find him or any information about his whereabouts.
Now let's start getting into your conclusions, starting with your opinion on the signatures in question. What is the first step you took in analyzing the signatures?
Well, first I had to get my hands on some known samples of Mr. Donaldson's signature so I could compare them to the signature on the purported will.
How did you go about this?
Well, I was able to obtain two signatures, as I mentioned before, and compare them to the June 14th will. So those signatures came from Lou Donaldson's temporary restraining order application.
I believe there was an objection, Your Honor.
What's the objection?
Your Honor, according to your pretrial motion ruling, the TRO would be used for the limited purpose of Mr. Donaldson's fear. Opposing counsel is attempting to use the TRO now for signature analysis, and that would be violating your pretrial motion.
Response?
Yes, Your Honor. We do plan to use the TRO as it was part of the basis of our expert's opinion. However, we will not be discussing any of the contents. We will not be saying any of the contents are true. We will not be discussing the divorce element that you have struck out before. All we will be using is the signature for its use on the basis as the basis of the expert's knowledge.
As an understanding of what the signature would look like.
Yes, Your Honor.
Yeah, as long as you keep it to discussion of just what the signature looked like, I don't see any harm in that. So I'm going to allow it.
Yes, Your Honor. Let me ask you again, Ms. Pride. So how did you go about obtaining the signatures?
Well, I obtained the two known signatures, one from Lou Donaldson's application for a temporary restraining order, and then another from his state-issued driver's license, and compared those to the will.
Marking page 40 in the record for identification, that's Bates marked 007, for identification as Plaintiff's Exhibit 7. Showing opposing counsel constructively. Ms. Pride, do you have a copy of what's been marked as Plaintiff's Exhibit 7?
I do.
Ms. Pride, do you recognize Plaintiff's Exhibit 7?
Yes.
How do you recognize it?
By its contents.
What do you recognize it to be?
This is the signature compilation relied on by Chris Renard in his report. So it includes the two signatures that I used in coming to my conclusion, the signature from Lou Donaldson's license and the one from the June 14th will.
Ms. Pride, are these signatures the same or substantially the same as the signatures that you used in coming to your conclusion?
Yes.
Your Honor, plaintiff offers plaintiff's what has been previously marked for identification as Plaintiff's Exhibit 7 into evidence as Plaintiff's Exhibit 7.
Any objection?
Objections, Your Honor. No objections, Your Honor.
All right, so entered.
Ms. Pride, what, if any, other signatures did you use in coming to your opinion?
I also used the signature on the temporary restraining order application.
Your Honor, pursuant to Local Rule 42H, I asked to publish a demonstrative using the signatures that Ms. Pride just testified to using in coming to her analysis. This demonstrative was, I I believe it was shown to opposing counsel. Yes, it was. Okay, thank you. This demonstrative was shown to opposing counsel prior to trial.
Right, you may publish.
Permission to set up the demonstrative, Your Honor?
You may.
Thank you. Your Honor, now ordinarily I would have the witness step down and notate the demonstrative with her findings, but due to the limitations of our format, the witness will be dictating the focal points of her investigation, and I will be marking them with Your Honor's permission.
That's fine.
Ms. Pride, after you collected these samples, how did you continue with your analysis?
Well, I started by handwriting analysis by just looking at the 2 known samples for handwriting characteristics.
What exactly were you looking for?
Well, when you're comparing signatures, they should look similar because people rarely alter their signatures over time. But they also shouldn't look identical because identical signatures is a sign of tracing.
Did you do that here?
Yes, I did.
And what did you find?
I found 5 characteristics in total in the 2 known signatures that established a baseline and indicated that these signatures were authentic.
Marking these signatures that were used to create the baseline. What was the first characteristic you noticed, Ms. Pride?
Well, first I noticed in both of the known signatures that the top loop in the L in lieu is smaller than the bottom loop, as you can see before you.
Marking the top and bottom loops in the L. Ms. Pride, you can see my notations, right?
Yes, I can.
What was the second characteristic you noticed?
Moving to the O in lieu, you can see that a small extra loop on the top of the O.
Marking the top of the O in lieu. What was the third characteristic, Ms. Pride?
Now moving to the U in lieu, you can see it has a small embellishment on its tail.
Marking the embellishment on the tail in lieu, in U in lieu. And what about that fourth characteristic?
So moving now to Donaldson, you can see that the last O is like not clearly written. It's difficult to even see that it's an O. This is what we call a lazy letter.
Marking the last O in Donaldson. And what about that fifth and final characteristic, Ms. Pride?
Finally, you can see the N in Donaldson has a similar embellishment to the one you see at the end of the U in lieu.
Marking the N, the embellishment in the tail of the N in Donaldson. Ms. Pride, do my notations indicate the 5 characteristics as you have testified here to today?
Yes.
How did these 5 characteristics impact your opinion today?
Well, they established a baseline for me to compare the signature on the will with and show me kind of what I should expect to see in Lou Donaldson's signature.
What opinion did you reach when you compared these baseline signatures to the signature on the June 14th will?
When I compared the baseline to the signature on the will, it led me to conclude that the signature on the will is definitely forged.
Let's talk a little bit more about that conclusion. Why do you think it's a forgery?
There are 3 main differences in the signature on the will and the known signatures that led me to conclude it was a forgery.
What was the first difference that you noticed, Ms. Pride?
Well, first in the known samples, the D in Donaldson is written in a single movement. However, when you look at the D in Donaldson on the will, you can see 2 distinct pen strokes, indicating that the pen was lifted and it wasn't written in one pen stroke as it was in the known samples.
Marking the D in Donaldson in all 3 signatures. What was the second difference that you noticed, Ms. Pride?
The second difference, if you turn to the last O in Donaldson, if you can remember before in the original documents, it was lazy, it wasn't clearly written, you can hardly tell that it's an O. But when you look at the O on the signature in the will, it's written very clearly.
Marking the last O in Donaldson. And what about that final difference you noticed, Ms. Pride?
Finally is the quivering lines in the signature on the will. This can be seen most clearly on the D and the L in Donaldson. These quivering lines are not present in the known samples.
marking the L and the D in all three signatures. Ms. Pride, do my notations indicate the three differences that you have testified to here today?
Yes, precisely.
Your Honor, at this time, the plaintiff moves to preserve this demonstrative as Plaintiff's Exhibit 6A.
Any objection?
No objections, Your Honor.
All right, so marked and so entered.
Let's turn now, Ms. Pride, what did these three differences indicate to you?
Well, first, it's indicating to me that the signer of the will picked up their pen more frequently than Lou Donaldson did in his first two signatures. Secondly, the quivering lines, as aforementioned in the D and the L, indicate to me that the writer was nervous and writing very slowly. This is common in forging because forgers will often write while looking at a known signature and attempt to copy it. So this led me to believe that the signature on the will, once again, was forged.
Let's take a second now and turn to your second opinion, that the contents of the will are likely that led you to believe that it's likely a forgery. How did you come to that conclusion?
Well, I analyzed the will's language as opposed to looking at the signatures, and was comparing it to other wills I've seen over the course of my career. And I've never seen another will that says if he dies or disappears, the estate would go to the beneficiary. Like I said before, I was a cop for 18 years, a private investigator for 4 years. I've read dozens of wills and documents of this nature, and I've never seen language like that. This led me to believe that the entire will is most likely fraudulent.
No further questions, Your Honor.
Cross-examination.
All right. Good evening, Ms. Pride. So first thing I want to talk to you about is your job. So you work for Pride Investigations Incorporated, correct? Ms. Pride?
Correct, sorry.
And that's your private investigation firm?
Yes,
You started this firm in 2016.
correct.
And just to be clear for the jury today, you are here being paid by the plaintiff, correct?
Correct.
You were hired by the plaintiff to investigate Mr. Donaldson's disappearance,
Correct. And analyze the will.
and you were hired in July of 2017.
Correct.
Now, Mr. Donaldson disappeared in August of 2012, correct?
Yes.
So your investigation actually didn't start until almost 5 years after Mr. Donaldson disappeared.
Yes.
All right. Now, I want to talk to you about your opinion of the Pioneer Sheriff's Office. It's your opinion that the Sheriff's Office didn't conduct a thorough investigation, correct?
Objection, Your Honor.
What's your objection?
May I have a moment to confer with co-counsel?
Sure.
Thank you. Yes, Your Honor. May I be heard outside the presence of the jury?
Okay, we'll take a sidebar.
Your Honor, opposing counsel is attempting to elicit testimony that falls outside of Ms. Pride's area of expertise. She was tendered as a forensic document and handwriting analysis expert. She did not opine on the sheriff's office or their investigation or anything about the sheriff's office.
Response?
Your Honor, in her direct examination, she stated that she has worked as a detective for years in the police department. She investigated economic crimes all the way up to murders. So her opinion to the sheriff's office investigation in today's case is highly relevant, and we need to hear this information.
May I be heard, Your Honor?
No, I'm going to allow it. Overruled.
All right, Ms. Pride, now I'm going to ask you that again. It's your opinion that the sheriff's office didn't conduct a thorough investigation, correct?
I can't speak to the sheriff's office investigation. I can only speak to my own investigation.
Well, in fact, actually, those were your own words, weren't they?
Did I state that the sheriff's office didn't do a sufficient investigation? I didn't think that that was something I said.
In your March 21st, 2020 report, you stated the sheriff's office did not conduct a thorough investigation. The answer to that question is yes.
Yes, there were elements that they did not include in their investigation.
All right, so at the time you had written your report, the sheriff's office had been investigating the disappearance for 7 years, correct?
Yes.
So the sheriff's office actually refused to release much information about their investigation to you, right?
Yes, they wouldn't release any information to me.
Because their investigation was still active.
Correct.
So the sheriff's office hasn't come to any determinations yet, have they?
They have not.
But the sheriff's office did inform you that they found no evidence of foul play, correct?
Yes, also correct.
And they've also informed you that Mr. Donaldson's body hasn't been found, correct?
Yes, they also informed me of that.
Objection, Your Honor.
What's your objection?
Hearsay.
Response?
Your Honor, these statements were part of this witness's investigation, and the jury is entitled to hear what they considered in their investigation.
I'll overrule. I'll allow it.
All right, Ms. Pride, let me ask you that again. The sheriff's office informed you that they never found Mr. Donaldson's body, correct?
Correct.
All right, now I want to move on to your investigation that you talked about earlier. You looked into the possibility that Mr. Donaldson flew away to Costa Rica, right?
Yes.
And your company decided to send a search party for him.
Yes, I sent one individual.
Right, your company only sent one person to search the entire country of Costa Rica for Mr. Donaldson, right?
Yes.
Your Honor, no further questions at this time.
Any redirect?
None at this. No, Your Honor.
All right, this witness may be excused. Call your next witness.
The plaintiff has no more witnesses, Your Honor.
All right, the plaintiff rests their case.
No, Your Honor. At this time, the plaintiff would like to play for the jury the video that was admitted in motions in limine.
Okay, so you're not closing your case.
No, Your Honor, you're not.
All right.
Your Honor, may we re-raise our objections from MILs and an additional objection as well?
What's your additional objection?
Your Honor, in the first paragraph of Exotic Bob's transcript, he states that him and Karen Baja, the defendant in today's case.
Want to do this outside the presence of the jury?
Your Honor, I apologize.
Okay, the jury was do this outside the presence of the jury.
Your Honor, so if the transcript or the video that they're going to show, the first paragraph states that Karen Baja and the Exotic Bob were working on a highly illegal deal. This information is unfairly prejudicial to the defendant. There's no probative value to that information, and is substantially outweighed by the danger of unfair prejudice and misleading the jury to make a decision based on the fact that this man, Exotic Bob, is stating that they're working on a highly illegal deal. And this would be also improper character evidence, Your Honor.
May it be heard, Your Honor?
No, I'm going to allow it. Let's go.
Yes, Your Honor. Permission to share our screen to show the video?
You may.
1 moment to set up, Your Honor. Your Honor, are you able to hear that?
Yes.
You see, it was 2 years, 2 weeks, and 2 days to the day that her husband was last seen alive. She and I was working on a highly illegal deal. We was illegally importing leopards and lions. Leopards was for her, leopards was for me, lions was for her. Now, we'd never worked together before, we'd never worked together since. But due to the severe illegality of the deal, we thought it best to be worked together, so we did. And at the end of that meeting, Karen Baja walked out of my office. She stopped suddenly, turned around, and she came marching back to my desk, and she leaned over and she looked me right in the eye and she said, "Exotic Bob?" That's me, Exotic Bob. She said, "Exotic Bob, I swear if you double-cross me on this deal, I will do to you exactly as I did to my husband." She said, "There won't be no disappearance, no mythical flight to Costa Rica." She goes, "Your last supper will be you. I'll feed you to my kiddies just like I did him." And then she turned around and she walked out of my office. That's all I've got to say about that.
All right, are there any portions of that defense that you'd like to play that in fairness should be heard at this time?
Your Honor, we would just like to read in an excerpt from the transcript. May I read it?
All right, you may read that portion from the transcript. Yes.
Excuse me, Your Honor.
Yes.
May defense counsel please give a indicator of what's being read into the record before he does so?
Yes, please. Please tell the plaintiff's counsel.
Outside the presence of the jury, sorry.
Yeah, assuming we're outside the presence of the jury. I'm going to read the paragraph prior to the one that you just played, stating that I am currently a guest of the federal maximum security hotel system, compliments of one Karen Baja, and that's what I am here to talk to you about today.
Thank you.
Okay, I'll allow that to be read. You may read that now to the jury.
This is the excerpt from Exotic Bob's transcript. I am currently a guest of the federal maximum security hotel system, compliments of one Karen Baja. And that's who I'm here to talk to you about today.
Okay, the jury can consider that as a portion of the video. Anything further from the plaintiff?
No, Your Honor, the plaintiff rests.
All right, plaintiff rests at this time.
Your Honor,
Yes.
prior to moving on, the defense has a motion to be heard outside of the presence of the jury.
All right, we will excuse the jury for a moment to hear a motion. What is your motion?
Yes, Your Honor. Your Honor, pursuant to Federal Rules of Civil Procedure 50A1, the defense moves at this time for a judgment as a matter of law on the claim of wrongful death. Even when viewing the evidence in the light most favorable to the non-moving party, in this case, the plaintiff has failed to put forth sufficient facts so that a reasonable jury could find for them in this cause of action. Specifically, Your Honor, the plaintiff has failed to meet the first element that Mr. Donaldson is actually dead, and also has failed to meet the second element of causation, that Ms. Baja was responsible for this death that they failed to prove. The plaintiff has provided no body. The plaintiff has provided also no death certificate or anything to indicate that Mr. Donaldson is in fact dead. And they have also not proven that there were any means, motive, or opportunity of Ms. Baja to cause that death.
Response.
Yes, Your Honor. Viewing the facts in the light most favorable to the plaintiff, we have presented a prima facie case of wrongful death. Specifically, as to showing that Lou Donaldson is in fact dead, we have shown that the defendant petitioned the court to have Lou Donaldson declared legally dead in order to inherit his estate and life insurance policy. Further, we have shown that nobody has heard from, seen, or been able to find Lou Donaldson in the last 8 years. In addition, none of his accounts or assets have been attached since. As it applies to whether the defendant caused the death of Lou Donaldson, we have shown that the defendant threatened to kill Lou Donaldson, and further, that the deceased believed the deceased feared the defendant would do so. We have also shown that the defendant forged a will to ensure that she would be the only beneficiary of Lou Donaldson's death. And we have presented the defendant's own admission to killing Lou Donaldson by feeding him to the lions, as per the testimony of Exotic Bob.
Any response to that?
Your Honor, we would just like to rest on our prior motion.
Okay. I'm going to overrule that motion at this time and note your objection for the record, but we'll proceed on. Do we need to take a short recess before we move on to the second half of the case, or would you like to just continue and pursue on right now?
Yes, Your Honor, we would like to take a short recess, or the defense side would like to take a short recess. And additionally, can we also have a time check?
Yes,
All right.
please.
Where are we with time?
I just sent a message to the other person to see what their time was, but I have time separately. As soon as we confer, I'll get you an official time.
All right. Well, can we
Yeah,
talk?
that-
Can we talk time after the break?
Yes, Your
Your
Honor.
Honor.
Give them the break time to figure it out. All right. How long do you need? 5 minutes? 10 minutes?
5 minutes is fine, Your Honor.
All right. 5 minutes. I have 20 after the hour. Let's meet back at 25 after.
Yes, Your Honor.
See you then. All right, are all our jurors back? You would just say yes.
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 Thank you. We're all here. A defense, call your first witness.
Yes, Your Honor. Your Honor, the defense would like to call the defendant, Karen Baja, to the stand.
I'm sorry, Your Honor, before we start defense case in chief, can we get that time check, please?
Oh, yes, I'm sorry. Time check.
Thank you.
Yes, I did send it to Your Honor as well. The plaintiff has used roughly 40 minutes. The defense has used about 14.
That doesn't seem right.
I have the same numbers. I had 43 minutes having been used and 14 minutes having been used.
Okay. All right. That includes the opens and the cross-examination.
Yes, stopping for all
Nominations?
objections. Yes.
Yes, Your Honor. It doesn't count motions in limine or halftime motions. It stops for all objections, but it does include times read in for the video as well as the transcript that the defense read in. Those two portions were counted. Everything else was not.
Okay. All right. As long as there's agreement. Defense, call your first witness.
Yes, Your Honor. The defense calls Karen Baja to the stand.
Karen Baja, you are pre-sworn.
Your Honor, may I inquire?
You may.
Good afternoon. Could you please state your full name for the record?
Hello, yes. My name is Karen Baja, and my last name is spelled Basia.
Ms. Baja, what do you do for work?
I'm the owner of Wild Life.
And do you own that company by yourself?
Yes, I do. It was the passion of both my husband Lou and I, and we ran it together up until he disappeared.
Now, you mentioned your husband. How did you two meet?
Well, it was one night almost 2 decades ago. I was walking, and Lou was kind enough to give me a ride, and the rest was just history.
And how would you describe you guys' relationship?
It was incredible. I mean, it was a fairy tale. Lou was truly my soulmate. And when you meet your soulmate, you just know right away. I mean, other people did give us some slack, but we never let it affect us. We always held true to who we were, and we loved each other.
How did Mr. Donaldson's family treat you?
They were never very accepting of me. I mean, they didn't like that there was an age difference between Lou and I. And his son, Cam, especially, was not favorable of me. But he started spreading these really crazy accusations and rumors about me after Lou had disappeared, which...
Objections, Your Honor.
What's your objection?
The witness well, I'm sorry, hearsay.
Response.
Your Honor, this witness has not testified to any statements that are being used for the truth of the matter asserted. This witness is simply saying the effect on the listener that statements that were made by the plaintiff in this case had on her.
Okay. Overruled. You may proceed.
Yes, Your Honor. And Ms. Baja, I'm going to ask you that question again. How was his family towards you?
Again, they just never really liked me. They didn't accept that there was an age difference between the two of us, and Cam, Lou's son, was especially hateful towards me, and things only got worse after he disappeared.
In what ways?
Well, Cam started spreading these just crazy rumors and conspiracies and fallacies about me when I just wanted answers the same way that he did.
Now, Ms. Baja, did you and Mr. Donaldson ever have any problems in your marriage?
I mean, yes, no marriage is perfect, and we were no exception to that, but we really loved each other and we worked through our problems. We had difficulties, but we always overcame them.
What problems were you all having?
Well, Lou had a mistress, and I found out about this because he would fly back and forth in his planes to see her in Costa Rica. But like I said, we were working through our problems, and we really did love each other.
And following up on this topic of planes, where exactly did your husband keep his planes?
He kept them at a variety of different hangars. My husband was a very secretive man, and this was one of those ways.
And Ms. Baja, let's go back to what happened on the 18th. Where was your husband?
I don't know. Lou had gone missing, and I truly had no idea where he was.
And after you found out that your husband was missing, what did you do?
Well, I waited and I hoped and I prayed every day that Lou would come back to me. But after 5 long years of wishing for him to come home, I realized that that was never going to happen. So, in order to close that chapter of my life and to be able to move our business forward, I filed to have Lou declared legally dead by the probate court.
Now, has Lou's remains ever been found?
No, no one has ever been able to find my husband's remains or any trace of him. And that's something that I still struggle with to this day.
Where is your husband today?
I don't know. And I mean, I really wish that I had the same answers that everybody else wants, but I just don't know. And I struggle with that lingering uncertainty.
Your Honor, a moment to confer.
You may.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. A brief moment to set up, please.
You may.
May I proceed, Your Honor? May I proceed?
Yes, sorry.
Good evening, Ms. Baja.
Hello.
Let's go back and talk about the night that you met Lou. You were 17 at the time, right?
I believe I was young around that age, yes.
You were standing on the side of the road.
I was walking, yes.
You were hitchhiking, right?
Your Honor, improper character evidence, may we approach?
Sure. Outside the presence of the jury, what's your objection?
Your Honor, the attorney just asked if our witness was a hitchhiker. That is improper character evidence. It is highly prejudicial against this defendant to label her as a hitchhiker. That term has negative connotations.
May I be heard, Your Honor?
You may. So you said it's improper character evidence? Is that what you said?
Yes, Your Honor, improper character evidence.
Okay.
Your Honor, my exact question wasn't if she was a hitchhiker. It was if she was hitchhiking that night, to which in her deposition, in her deposition, she said she was.
Yeah, I'm going to allow it. Overruled.
Yes, Your Honor.
Let me ask you again, Ms. Baja. You were standing on the side of the road, right?
Yes.
You were hitchhiking, right?
Yes, I was.
You came from a poor upbringing, right?
I definitely had lesser than most, yes.
And you had nowhere to go that night?
No.
And that's when Lou saved you, right?
Yes, Lou was kind enough to give me a ride that night.
Right? And on direct, you claimed that you fell in love with him, right?
Absolutely.
You called him your soulmate, right?
That's correct.
You called him your Prince Charming.
Yes.
And then in 2001, you married Lou, right?
I did, yes, in September.
Now, as Lou's wife, well, first, Lou supported you financially, right?
We ran Wild Wildlife together.
As Lou's wife, well, Lou was a self-made entrepreneur, right?
Yes, that's how he built his business.
As Lou's wife, you didn't have to stand on the side of the road anymore, did you?
No.
As Lou's wife, you didn't have to hitchhike anymore, right?
No.
You had a home now.
Yes.
You and Lou even started what you called your own furry family, right?
Yes, that's correct.
Now, I want to go on and talk about what happened to your marriage over the years. Things didn't stay great forever, right?
We had our own difficulties, yes.
I mean, as you put it, you guys weren't perfect.
No, no relationship is, and we were no exception to that.
On direct, you said that Lou was secretive, right?
He was a very private man, yes.
You claimed that you don't even know about you didn't know about his travels, correct?
He traveled often for business, and I wasn't always fully aware of what exactly he was doing. That's correct.
Ms. Baja, a yes or no answer will suffice. Let me redirect you back to my question. You said that you didn't always know about his travels, right?
That's correct.
And you said that you didn't even know how many planes he owned, right?
Yes.
In fact, you said you didn't even know where he was the night of August 18th, right?
That's true.
But in June, Lou did tell you that he had a mistress, right?
Yes.
That mistress was in Costa Rica,
Yes.
and that he was flying out to go visit her.
Yes.
And then June 12th, he filed for a temporary restraining order against you, right?
Yes, that's correct.
Let's take a second and go back and revisit that August 18th night. That was the night that you claim Lou disappeared, right?
That was the night that Lou disappeared. Yes.
You claim that you weren't home at the time, correct?
No, I had gone to the store.
Right. You went to the store to buy milk and formula, right?
Yes, we had a tiger at Wild Wildlife who had some cubs and she rejected them. So I was their primary caretaker and I was waiting on them hand and foot.
Ms. Baja, once again, I'll redirect you back to my question. A yes or no answer will suffice. You went out to buy milk and formula because you had a newborn tiger cub or some newborn tiger cubs at Wild Wildlife, right?
Yes.
Directing court and counsel to what has been previously entered into evidence as Plaintiff's Exhibit 2. Permission to publish, Your Honor?
You may.
Ms. Baja, this is Lou's bank statement, right?
Yes, that's correct.
The last charge on this bank statement is dated August 17th, 2012, right?
Yes.
That last charge right there is for Summit Animal Supply.
Yes.
That charge is for about $940.
It says 940 and 10 cents. Yes, that's correct.
Right. $940.10 worth of animal supplies, right?
It's from the animal supply store, but I'm not sure exactly what the contents of the purchase was.
Ms. Baja, you're saying that an animal supply store doesn't sell animal supplies right now?
Yes, I am saying that this was made at the animal supply store. Yes.
But you're also saying that the animal supply store doesn't sell animal supplies.
All that I was saying was I don't know what the exact items were that were purchased at the supply store, but it is animal supplies. Yes.
So I'll redirect you back to my original question then. It's $940.10 worth of animal supplies, right?
Yes.
Let's go back. I'm sorry. Let's talk about your cats a little bit more. Ms. Baja, you help feed your cats, right?
Yes, I do.
And a tiger's diet consists primarily of meat, right?
Yes, I mean, they don't eat corn or salads.
Exactly, they don't eat corn. In fact, tigers eat about 88 pounds of meat each day, right?
I am not aware of that information.
So you own your own meat grinder, right?
We do have a meat grinder on the premises, yes.
And you use that meat grinder to prepare all of the tiger's food, right?
Yes, that's correct.
And I'm sorry. In fact, that meat grinder is so big that you guessed you could fit an adult human into it, right?
I mean, yes, it's very large in size.
Ms. Baja, that wasn't my question. My question was, you guessed that you could fit an adult human male in it, right?
I suppose.
But it's also so big that you need 2 people to operate it, right?
Yes.
Your brother was with you in the early morning hours of August 18th, right?
Yes, he was.
Your brother, the sheriff's deputy?
Yes, that's correct.
Let's move on and talk about the June 14th will. In June, Lou tells you that he had a mistress in Costa Rica, right?
That is correct, yes.
And then June 12th, he files an application for a temporary restraining order against you, right?
Yes.
Your Honor, permission to republish what has been previously marked as Plaintiff's Exhibit 6 in evidence?
May.
Ms. Baja, this is Lou Donaldson's temporary restraining order, right?
Yes.
In it, it says that Lou Donaldson requests the court issue a temporary protection order.
Yes.
It says that Karen Baja that's you, has threatened to kill me.
That's what it says.
And then that last line right there, it says, I do not feel safe around Karen Baja, right?
That's what it says.
And then June 14th, he signs everything over to you in a will, right?
Yes, that's correct.
That's just 2 days after this temporary restraining order, right?
Yes, 2 days after the restraining order that was denied.
That's not my question. My question once again was, that was just 2 days after the temporary restraining order, correct?
Yes, that's correct.
Let's talk about the inheritance you got from the June 14th will. Ms. Baja, you inherited all of Lou's estate, right?
Yes.
That estate's worth about $10 million?
Yes.
Of that $10 million, $5 million was from a life insurance payout, right?
That is correct.
On direct, you said that when Lou disappeared, you hoped and prayed that he would come home, right?
Yes, for 5 long years.
Right. You never tried to go to Costa Rica to find your beloved husband, did you?
I have no knowledge of that subject.
You have no knowledge of whether you went to Costa Rica or not?
I have no knowledge on that subject.
Ms. Baja, it's your testimony today that you have no knowledge on whether you went to Costa Rica or not.
Correct, I have no knowledge on that subject.
Your Honor, may I have a moment to confer?
You may.
Ms. Baja, you never tried to find any information on your soulmate, right?
I'm not sure I quite understand the question. In what way?
I'll rephrase. You never asked around Statesville to try and find information on your soulmate, right?
I don't have any information on the subject of whether or not I tried to contact others regarding Lou, but I kept in contact with the sheriff's office regarding their investigation.
Ms. Baja, you never offered a reward for information on your Prince Charming, did you?
I have no knowledge of that subject.
You never tried to hire a private investigator to find your beloved missing husband, did you?
I have no knowledge on that subject.
Well, do you have knowledge of whether you tried to use any of your money to try and find your beloved husband?
I have no knowledge on that subject.
No further questions, Your Honor.
Can you redirect?
Yes, Your Honor. Ms. Baja, how long did you and your husband run Wild Wild Life together?
Gosh, it was from the time that we were married, so almost 2 decades.
And now you mentioned that you took over Wild Wild Life. How are you running it by yourself?
Well, Lou left me all of his assets as well as his life insurance policy so that I could continue to run Wild Wild Life. So I've been able to use that money to continue our business and further Lou's legacy through our passion.
And you mentioned that you and Cam's relationship wasn't good. When did that relationship start to get bad?
Well, it really went sour after Lou disappeared and Cam just started creating these crazy fallacies about me. I mean, just wild conspiracy theories.
Your Honor, no further questions.
May this witness be excused?
Yes, Your Honor.
All right, you may be excused. Call your next witness.
Your Honor, the defense calls Chris Renard to the stand.
Mr. Renard. Mr. Renard, you are pre-sworn. You may begin your examination whenever you're ready.
Good evening. Could you please state your name for the jury?
Yeah, my name is Chris Renard. Last name is spelled Renard.
What do you do for a living, Mr. Renard?
So I am a investigator and a forensic document examiner for Summit Life Insurance Company.
Can you explain to the jury what your job entails?
Yeah, so I do risk surveys to assess losses. I conduct evidence, investigations, insurance claim review. I question people regarding insurance claims, but I specialize in handwriting and signature identification.
And how long have you been an investigator and document examiner for Summit Life Insurance?
So I've worked there for about 20 years now.
What is your academic background for this job?
Well, before I did this, I started out in 1997 with the Statesville Police Academy. I graduated from there. I also graduated from Summit College in 1996 with a bachelor's degree in criminology specifically.
And so after you started working at Summit Life Insurance, did you do any continued education?
Yeah, I have to actively participate in training workshops and continued education courses in the field of forensic document examination, as well as insurance claim investigations.
What type of certifications do you have?
I have a certification from the Board of Forensic Document Examiners, as well as a certification from the Association of Certified Fraud Specialists.
Now, have you ever testified in court before?
I have. I've testified a total of 25 times in the field of document examination.
All right. So as a forensic document examiner, what type of documents do you typically look at?
Well, working for a life insurance company, a lot of different stuff: wills, bank records, driver's licenses, and anything else that we would need to look at in an insurance claim investigation.
Now, you said you looked at wills. How many wills would you say you've examined in your time?
Over the past 20 years, hundreds of wills.
All right. Well, let's get into why you're here today. How do you know the defendant, Karen Baja?
I was assigned to be the claims adjuster on her husband's $5 million life insurance policy.
And who asked you to investigate this?
My boss, who is the CEO of Summit Life.
And what specific reasons were you asked to look into by your boss?
Well, we were aware of two allegations, specifically whether or not we had to pay out on the claim because of an allegation that Ms. Baja killed her husband and an allegation that the will was a forgery. So I looked into seeing if we had to pay out.
Now, without going into details, were you able to come to any conclusions on that payment to Ms. Baja?
Yes, I was.
And when coming to your conclusion, was your conclusion based on reliable principles and methods?
It was.
Was it based on sufficient facts and data?
Yes, I conducted a very thorough investigation into those two claims.
Your Honor, may we approach?
For what purpose?
This time, Your Honor, we would like to tender Chris Renard as an expert in insurance claim investigation and forensic document examination.
Any objection?
Yes, Your Honor, to the first tender, insurance claim investigations, it's much too broad of a subject. Further, outside the presence of the jury, I presume. Further, the witness has not testified to any certification, reliable principles and methods, whether or not he has been tendered as an expert in insurance claims investigations before, or whether he's been whether he's published on that subject.
Response?
Your Honor, the witness previously testified that they've been working for Summit Life Insurance for 20 years, doing this exact job that they've done. They've also testified for Summit Life Insurance before. Additionally, Your Honor, the witnesses testified that their conclusions were the product of reliable principles and methods, and it was based on sufficient data and facts.
All right, I'm going to allow it. I'll allow the witness to testify.
All right, Mr. Renard. So let's talk about those two reasons your boss asked you to look into. First, with the possibility that Ms. Baja killed her husband. What conclusion did you come to regarding payment on that reason?
So based on my investigation, what I looked into, we did not have the grounds to contest that $5 million payment on the allegations that she killed her husband.
All right, well, let's talk about how you came to this determination. When was the last time that Mr. Donaldson was seen?
So he was last seen on August 17th of 2012.
What evidence did you consider on top of this when coming to your conclusion?
So I looked into his bank statements. I also spoke with the Pioneer Sheriff's Department. I spoke to his family, some of his associates and coworkers as well.
All right. Are those conversations ones that someone in your field would rely upon?
Yes, I mean, we obviously would want to conduct interviews to verify any claims.
All right, so let's talk about what you learned from the Pioneer Sheriff's Office. What did they tell you?
A couple of things. First off, I learned that they had not charged or even listed Karen Baja as a suspect since her husband disappeared. And then I also found out that she had an alibi for part of that night.
Now, you said that the sheriff's office hasn't listed Ms. Baja as a subject. What, if any, evidence has the sheriff's office found of Mr. Donaldson?
So they found evidence in his van. They found some keys and glasses in his van, but they didn't find any other indications of a struggle or anything of that nature. So that was the extent of what they found.
We heard earlier about a meat grinder. What information did you consider about this?
Well, the police confirmed that there were some rumors of a meat grinder, but that's just all they were. They were just rumors. And in those conversations, I was able to just glean from what they told me that traces of DNA or human blood in them.
Mr. Nard, you broke up a little bit, and I'm not sure if everyone else could hear you or if it was just me. But could I get you to repeat the answer? I'm sorry.
Yeah, sure. So from what I learned from the police department, there were just rumors of a meat grinder being used, but that's all they were. They were just rumors. I gleaned from talking to them that there was no DNA or anything found, because if there was, they would have charged her with something.
All right, well, now let's move on to the possibility that Ms. Baja forged the will. What was your conclusion regarding payment based on that reason?
So yeah, after I investigated the forgery elements, it was my opinion that we could not deny payments on that life insurance policy based on it being a forgery.
All right, now let's talk about how you came to this conclusion. What was the first step you took to determine if the will was forged?
So first I started off by obtaining copies of Mr. Donaldson's signatures. I started with one that we had in our office from the life insurance that he filed back with us in 2005. Then I pulled his driver's license that was on file with the DMV, and that had a signature with photo attached to it. And then I compared those two signatures to each other, and those two matched.
Your Honor, may I publish what has been previously entered into evidence as Plaintiff's Exhibit 7?
You may.
All right, Mr. Renard, can you confirm that you can see this on the screen?
I can.
All right. Mr. Renard, what is the signature at the top of this report?
That would be Mr. Donaldson's signature from his life insurance policy paperwork.
And what is the signature in the second box?
That's the signature I got from his driver's license.
And what is the signature in the last box at the bottom?
That was the signature on the last will and testament that was provided to us.
All right. Based on your expertise as a forensic document examiner, what conclusion did you come to about that signature in the bottom box?
It was my professional opinion that the signatures had some differences between them, but they were not sufficient enough for me to make a finding that the signature on the will was a forgery.
You mentioned that there were some differences. What did you think of those differences?
Again, I thought that there were some, but they were not sufficient enough for me to make any determination. I didn't find them to be enough of a conclusory difference.
All right, Mr. Renard. So what, if any, possible reasons could a signature be different?
Well, there's a lot of reasons. The age of the person, the health. There's sometimes they just change it depending on the day of the week. You can't really tell when a person is going to change it, but age and health are some big factors of it too.
All right. Your Honor, a moment to confer.
You may.
Mr. Renard, I have a couple more questions to ask you really quick. So what was we've talked about each of the individual reasons that you investigated in your conclusions based on those, but what was your overall determination for contesting the $5 million payment to the defendant?
It was my overall opinion that Summit Life Insurance did not have enough evidence to contest the payout to Ms. Beja.
Now, what benefit, if any, did Summit Life Insurance receive from coming to this conclusion?
Other than just maybe avoiding some litigation costs, we didn't have any benefit. If anything, we're actually out $5 million now. So,
Your Honor, no further questions at this time.
Cross-examination.
Yes, Your Honor. May I proceed?
You may.
Mr. Renard, you admit that it is possible that the signature on the June 14th will is forged.
possible, but not probable.
You would say that the 3 signatures that you made, or sorry, permission to publish what has been entered into evidence is Plaintiff's Exhibit 7.
Sure.
You would say that the 3 signatures that you compared were not exactly the same.
That's correct.
There were enough differences between the June 14th will signature and the 2 baseline signatures that your finding was inconclusive.
Yes.
Your recommendation to Summit Life Insurance was to pay out the policy to avoid costly and lengthy litigation.
That's right. I didn't think we had enough evidence to pursue that route.
I'd like to direct your attention to the language used in the June 14th will. Permission to publish what has been entered into evidence is Plaintiff's Exhibit 1.
You may.
The June 14th will states, if I should die or disappear, I give to Karen Baja absolutely all my real and personal property whatsoever. Did I read that correctly?
That's what it says, yes.
You've been an insurance investigator for 20 years?
That's right.
In those 20 years, you would say you have reviewed hundreds of wills.
That's right.
You have never seen another will with the language die or disappear, correct?
No, I haven't.
You'd also say that this language, die or disappear, is an indicator of fraud.
I don't know if I'd go that far.
You would say that it was suspicious.
Suspicious, but I don't think I would use the word fraud.
Directing you back to my question, you would say that the language die or disappear is suspicious.
That's what I said.
I'd like to discuss the information you based your conclusions on. You requested the release of evidence from the Pioneer County Police Department, correct?
I did.
They denied your request, citing the investigation was still active.
That's right.
You have an inside contact at the Pioneer Police Department.
Yeah, I've got some buddies there.
That inside contact gave you what you would say nuggets of information.
Right.
Nuggets of information on the investigation into Lou Donaldson's disappearance.
Exactly.
Your contact, you've been in law enforcement. You used to work in law enforcement, correct?
Yes, I did.
Your contact broke the rules in giving you the information you received.
I don't really know, actually.
You don't know if they broke the rules?
I'm not familiar with that local sheriff's department's rules. I was a police officer, not a sheriff's officer.
Okay. You can't give us your contact's name, correct?
No, I'd rather not.
You'd rather not. Mr. Renard, you are aware that the defendant's brother is a sheriff's deputy in the Pioneer County Police Department?
I am aware.
The same department investigating Lou Donaldson's disappearance?
Yes.
I'd like to talk more about how you conducted your investigation. You can't show this jury any video footage from the airstrip that Lou Donaldson's van was found at.
I have no knowledge of a videotape that would have been taken, no.
You don't have any video footage to show this jury today.
I definitely do not.
You can't show this jury any forensic reports on Lou Donaldson's van.
No.
You don't have any record of flight plans for Lou Donaldson.
No.
You can't tell us the name of anybody in Costa Rica that you spoke to looking for Lou Donaldson.
That was not my charge, so I did not do that.
You didn't even speak to anybody in Costa Rica looking for Lou Donaldson.
Again, that wasn't my assignment.
You also don't have any reports of plane crashes en route to Costa Rica.
I have no knowledge of that.
You can't show this jury a forensic report on the meat grinder that the defendant has.
No.
You don't even know if the police, in fact, tested the meat grinder.
I was able to determine that from my conversations, but I cannot show you definitive proof of that.
So directing you back to my question, you don't know for sure whether or not a test was even conducted on the meat grinder.
In my mind, I do know.
But you can't show this jury any results from said test.
I cannot show a test result, no.
Rather, you would say that you gleaned that the police tested it, correct?
Yeah, that's what I said.
Mr. Renard, it is your testimony today that the June 14th will and testament of Lou Donaldson appears to be genuine, yes?
That's correct.
In coming to this conclusion, you did not consider Lou Donaldson's application for a temporary restraining order against the defendant.
No, it was denied, so I didn't find it informative.
Directing you back to my question, you did not even consider that document.
I think I answered your question, but no, I didn't.
The application for a temporary restraining order was filed on June 12th, 2012, correct?
Yes.
Just 2 days before the June 14th will was signed.
Sure, yeah.
No further questions.
Any redirect?
Yes, Your Honor. Mr. Renard, can you hear me okay?
Yes, I can.
Your Honor, may I inquire?
You may.
Mr. Renard, what benefit, if any, did you receive from coming to the conclusion that you did?
Objection, Your Honor. Outside the scope of cross-examination.
You rephrase the question, please?
Your Honor, may I be heard first?
I'm just asking you to tell me what your question was again.
My question was, what benefit, if any, did Mr. Renard receive for coming to his conclusion? Bias is always relevant, Your Honor.
Okay, and this is your witness?
Your Honor, may be heard.
I'll allow it, overruled.
All right, Mr. Renard, I'm going to ask you that again. What benefit, if any, did you receive personally for coming to the conclusion that you did?
None at all. Our company had to pay out a $5 million policy, so I didn't get any benefit out of that.
Your Honor, no further questions at this time. May this witness be excused?
You may. Call your next witness.
Your Honor, the defense has no further witnesses to call, but we would like to read in a portion of the transcript from Carl Bannister's deposition.
Okay.
May be heard, Your Honor.
Yes, is it an unavailable witness?
Yes, Your Honor.
Yes.
Okay.
Can
Have
we
you
just
shown
get,
have you shown opposing counsel which portions you want to read in?
No, Your Honor, I have not yet, but I can proffer to her what I'm going to read in.
Okay, please do that.
Assuming we're outside the presence of the jury, I'm going to read in the statement from Carl Bannister's deposition where He was asked, were you involved in the investigation of the disappearance of Lou Donaldson? Answer, no, it would not have been appropriate. I mean, I know the detectives and investigators who looked into it. I have not been working with them for years. I have been working with them for years, and we are all pretty close, but I was not personally involved in the investigation. Next question. Did you have a chance to view any evidence or look at reports? No, I take my job seriously. I knew nothing of Lou's disappearance, and I want to keep it that way. I was walled off from the investigation, and that was fine by me. That concludes what I'm going to read to the jury, Your Honor.
Any substantive objections to that?
A moment to confer with co-counsel, please.
Sure.
Your Honor, we have no counter designations.
Okay. Then I'll allow Mr. Troutman we'll bring back the jury and allow Mr. Troutman to read in the portions of Carl Bannister's statement.
Excerpt from Carl Bannister's deposition. Question, were you involved in the investigation of the disappearance of Lou Donaldson? No, it would not have been appropriate. I mean, I know the detectives and investigators who looked into it. I have been working with them for years and we are all pretty close, but I was not personally involved in the investigation. Question, did you have a chance to view any evidence or look at the reports? Answer, no, I take my job seriously. I knew nothing of Lou's disappearance and I want to keep it that way. I was walled off from the investigation and that was fine by me. Your Honor, that concludes the excerpt from the deposition.
Plaintiff, would you like to read any other portion of that deposition for cross-examination?
No, Your Honor.
All right. Defense have any other witnesses or any other information to present to the jury?
No, Your Honor, we have no further witnesses to call.
All right. So you close your case?
Yes, Your Honor, we would like to renew our motion, our mid-trial motion.
All right, and will be noted for the record and overruled at this time. Are we ready to proceed to closing argument?
May we have a brief recess before closing arguments, Your Honor?
Sure. Can we get a time check and see where we are?
Yeah, of course. Just give me a second to talk to Taylor Pride and we'll figure it out.
All right.
Your Honor, we also ask during this brief recess to meet with opposing counsel to discuss any demonstratives used during closing arguments.
Okay, that will be fine.
Thank you.
How would you like to meet?
Does Your Honor have the capability of putting us in a breakout room?
I can. I'll go ahead and dismiss the jury while we are waiting on the time check. I have 10 after the hour. Let's come back at 20 after the hour for closing arguments. The jury is dismissed. And as soon as we get a time check, I will send you to your breakout room to discuss your exhibits. Are you
All right,
off?
so
Go ahead.
okay, so we've got 57 minutes used by the plaintiff, which gives you 13 left for closing arguments, and 29 minutes used by the defense, which gives you essentially 40 minutes for closing arguments.
Yeah, you don't have to use all that time.
Yes.
So. All right. All right, send you to your breakout room. All right, are all our jurors back?
Yeah. Yes.
Yes.
All right, super. Counsel, are you ready for closing arguments?
Yes, Your Honor. Before I begin, pursuant to local rules, I will be using a PowerPoint presentation during my closing argument. It has been shown to defense counsel prior to this argument.
Okay. And there's no objection to anything on the PowerPoint?
No, Your Honor.
Okay.
Also, I ask that any time I have remaining be reserved for rebuttal.
Okay. Will do.
With that, I'm ready to begin.
Okay. You may proceed.
The timeline, it tells it all. In early June of 2012, the defendant threatened to kill Lou Donaldson because he asked for a divorce. Just a few days later, on June 12, 2012, Lou Donaldson files an application for a temporary restraining order against the defendant. June 14th, the date of the disputed will that left everything to the defendant. In early August of 2012, the defendant and Lou Donaldson fight yet again about divorce, and Lou Donaldson leaves visibly shaken. August 17th was the last day that Lou Donaldson was seen alive. And on August 19th, just 2 days later, the defendant breaks into the wildlife office and steals Lou Donaldson's original will. And later, the defendant presents a fraudulent will, one that allows her to inherit everything. We have met our burden in today's case. We have proven that it is more likely than not that the defendant caused the wrongful death of Lou Donaldson. Lou Donaldson is dead. The defense can barely dispute this because the defendant said he was dead when she wanted to inherit his $5 million estate. The defendant admitted Lou Donaldson was dead when she wanted to get the $5 million insurance policy payout. But she won't admit that he was dead today because the truth doesn't matter to the defendant. Money does. But we presented you with even more evidence than this. We showed you that nobody has seen or heard from Lou Donaldson in 8 years. Lou Donaldson did not fly off in a private plane to be with his girlfriend in Costa Rica. That is why Taylor Pride's employee could find no trace of Lou Donaldson in Costa Rica. That is why none of Lou Donaldson's assets or bank accounts have been touched since he was last seen alive. Cam Donaldson knew of every other trip his father took, but not this one, because it didn't happen. What happened is the defendant wrongfully caused the death of Lou Donaldson. This application for a temporary restraining order shows Lou Donaldson's fear of the defendant. Just a few days after a fight, Lou Donaldson went to the court and asked the court for protection, for help, because he feared he was in danger. Look at Lou Donaldson's words. Karen Baja, the defendant, has threatened to kill me. I do not feel safe around Karen Baja. Look at his fear. Just 2 weeks before Lou Donaldson disappeared, the defendant and Lou Donaldson had another fight over divorce, and Lou Donaldson left visibly shaken. The defendant's marriage, saving the defendant's marriage was not certain, so she made a plan that was. She forged a new will, made herself the sole beneficiary, and she got rid of Lou. The June 14th will cannot be authentic. The Lou Donaldson's legitimate will split his estate into 4 parts in the event of his death. But after August 17th, the defendant produced a new will, one dated on June 14th. I submit to you that Lou Donaldson did not voluntarily sign this will, leaving everything to the defendant just 2 days after he filed for a temporary restraining order against her. It is not more likely than not. What's more, both of the experts that you've heard from today admit that the language used in this will, die or disappear, is suspicious. It's suspicious because the defendant used that specific language knowing Lou Donaldson would never be found. Both of the experts agree that it is possible that the signature on the June 14th will is forged. Taylor Pride explained to you how her expert eye could tell that this was a forgery. Here, you see the vast differences in pen strokes, letter formation. You can see the hesitation marks. Members of the jury, you can tell for yourselves that this signature is a forgery. The handwriting comparison is enough to meet our burden that the will was forged, but we showed you even more. The defendant stole Lou Donaldson's original will. On August 19th, 2012, the defendant broke into the Wild Wildlife office and stole Lou Donaldson's original will out of Cam Donaldson's desk. Here, you can see the lock and the gate broken into. But when police tried to question her, she admitted that she was the owner of Wild Wildlife. She smirked at Cam Donaldson. The defendant knew she could break into Wild Wildlife and make those statements to the police because she knew that Lou Donaldson was never coming back. Follow the money. The defendant is the only person to benefit from Lou Donaldson's death or disappearance. What's more, the defendant's story about the night of August 17th doesn't make sense because it didn't happen. The tiger kittens that she testified about, they were born before Lou Donaldson disappeared. And you saw, members of the jury, Lou Donaldson's bank account statement, one where he bought $490 worth of animal supplies on August 17th. It does not make sense that the defendant needed to go to a 24-hour market for milk and formula just hours after this purchase was made. It doesn't make sense because it didn't happen. What happened was the defendant was with her police officer brother, disappearing Lou Donaldson. The timeline, it tells it all. Cam Donaldson, the timeline, it tells it all. Cam Donaldson misses his father every day. They worked together. They were huge parts of each other's lives. The defendant should not inherit any of Lou Donaldson's money because she's the one who killed him. Lou Donaldson's money belongs to his family, to his estate. And that is why we ask that you deliberate carefully and reach the only conclusion that reason and the law allows. Find the defendant liable for the wrongful death of Lou Donaldson and award his family $10 million in damages. Thank you.
Your Honor, you're on mute.
Apologize.
No problem.
Thank you, plaintiff's counsel. Ms. Mateer, are you ready for your closing argument?
Yes, Your Honor. May I inquire?
May you inquire?
I'm sorry. Yes, Your Honor. May I please the court? I apologize.
Okay, you may proceed.
Yes, Your Honor. May I please the court, counsel, members of the jury. In an attempt to understand things that are difficult and too upsetting to come to terms with, sometimes our minds hold on to intricate, complex, and irrational explanations. They make you feel better, and they provide you with closure. They give you someone else to blame, a scapegoat. And members of the jury, that is exactly what you were presented with today. But as Mr. Troutman said at the beginning of this trial, and as we all now know, the simplest explanation is the only explanation. Now, the plaintiffs, they said something at the beginning of this trial. I had to write it down. They said, 2 birds, 1 meat grinder. That's what the plaintiff came before you with. Conspiracy theories, unsupported accusations, and they took you all on a wild goose chase in an attempt to explain why his father disappeared, why he left him. But Lou Donaldson, he didn't just leave his son when he disappeared on August 17, 2012. No, on that day, he also left his wife, his soulmate, our client, Karen Baja. And today you all had the opportunity to meet Miss Baja, a woman with a passion for animals who thought that she had found her forever love. An abandoned wife trying to find closure and peace with the fact that after 12 years of marriage, her husband, he just walked out of her life, never to return again. And earlier, my co-counsel, Mr. Troutman, he came before you and he spoke to you about why we are here today. Our client, she's being accused of causing the death of Mr. Lou Donaldson. And in only a few moments, you will be the ones to determine the outcome of this case. It is important that you remember, as Mr. Troutman said before, that it was the duty of the plaintiffs to prove their case to you by a preponderance of the evidence, a burden that they have failed to meet. And they failed to meet it because our client, she's not liable. And in an effort to tarnish the reputation of this woman, the plaintiff, they bought you irrational conspiracy theories. They failed to provide you with any actual facts, and they refused to acknowledge the simple explanation that we all know to be true. The explanation is that Mr. Donaldson, he left his family, he left his wife, and he left his business behind. And no one, not the plaintiff, and especially not my client, know where he is today. And they don't know that because Mr. Donaldson, he didn't want them to know. Now the plaintiff, they have failed to meet the required 4 elements in this case. These elements right here. And let's talk about them. The plaintiff, they failed to prove that Mr. Donaldson is dead. They did not provide you with a death certificate. They didn't provide you with a body. Is that enough? Is it? No, members of the jury, it is not enough. What they did come to you with, though, today was conspiracies and half-baked investigations, not evidence, not facts. Their expert witness, Miss Pride, you remember her. She told you that Mr. Donaldson never stepped foot into a whole other country. Miss Pride, she didn't mention, though, that she didn't look anywhere else. And my client's husband, he had access to several planes and he was a pilot. You all learned that today. He could have literally gone anywhere else. But Mr. Pride, she never looked. She was blinded by her employer, Cam Donaldson, who was obsessed with this conspiracy that my client was responsible for Mr. Donaldson's disappearance. However, we brought you evidence of the sheriff's office and ongoing investigation, and they did not suspect any foul play. And my client, she has never been a suspect. But despite all of this, The plaintiff is asking you to come to a conclusion in one day that the sheriff's department hasn't been able to come to in 8 years, members of the jury. The plaintiff failed to show you that my client was responsible for the death that they failed to prove. And the plaintiff, she fed you this conspiracy theory about what happened to Mr. Donaldson. They told you that our client filed to have her husband declared dead. But members of the jury, this was not something done in deceit, nothing that was suspicious or a cause for concern. Our client, she had been waiting in agony for her husband to return to her. And you heard from her today. She told you that she waited for 5 long years for him to come back, for some answers, that she is still waiting for answers. She filed not in deception, but she did so with a hope for closure. And she was simply trying to move on, start a new chapter in her life, continue to take care of wild life, and get back to living. But the plaintiff could not bear to see the woman that her father was married to for over a decade inherit everything and her inherit nothing. She was angry that her father left my client everything. And you saw her rage today. One that you saw it play it right out before your eyes, members of the jury. The plaintiff failed to show that my client was responsible for anything. And there is no denying that this has been a difficult experience for all those that were involved. My client is also, as you saw today, still deeply troubled and confused and sad about the fact that her husband, he left her. She still wants those answers. They both want answers. But unlike the plaintiff, Miss Baja, she's not hell-bent on trying to pin false accusations on another person. The root of the problem in this case is Mr. Donaldson, not my client. She is simply another victim of his selfish actions. And finally, members of the jury, the plaintiff has failed to show that our client is responsible for any of the pain that the plaintiff feels about the disappearance of their father. The plaintiff tried to convince you that my client forged her husband's will. But today you heard from Mr. Renard, a man who works for the insurance company, a company that would benefit from not having to pay anyone money, especially not $5 million. And he told you that after completing his investigation, he did not find that the will was forged. And he has been investigating documents for 20 years. Mr. Renard did not find any grounds to contest the payment of that insurance policy to my client. Now, the plaintiff, she wants you to believe that Ms. Baja is this evil, money-hungry person. But the reality is that the plaintiff was angry that he did not get any inheritance from his father. He was angry that he left wild life to the defendant and not him. Now, he could not accept that the person he was really angry at was Mr. Lou Donaldson. And you heard the plaintiff before me. They asked for you to award them with $10 million in damages. Members of the jury, it is clear that the plaintiff did not meet their burden today. They failed to prove to you all of these elements. However, I can't read your minds. And when you go back into that back room, someone might ask the question, what if we look at the verdict form that the plaintiffs showed us? What then? Well, on the outside chance that you even consider damages, that number, it should not be one dime more than the $2.5 million that this plaintiff claims was in her father's original will. It should not be $10 million. Now, this will be the last time that I have the opportunity to speak to you all. But the plaintiff is going to come back up here after me. And when they do, Members of the jury, I want you to ask them these questions. I don't want you to let them leave until they answer them. Is Mr. Donaldson even dead? Why is the plaintiff trying to make you make a $10 million decision that the sheriff's department has not even come to themselves? And is there a simple and reasonable explanation for everything available? And when the plaintiff comes back up here, they're going to do one of two things. They're either going to attempt to answer these questions and fail, or they're not going to try to answer these questions at all. And when that happens, you'll have your answer. When you go back to deliberate, you all will have the opportunity to consider all of the evidence that you saw today, the testimony that you all heard, and most importantly, your own common sense to come to the only conclusion in this case supported by the facts. Sometimes the simplest explanation, it is the only explanation. And when you receive this verdict form right here, you should find for my client, Karen Baja, bring this nightmare to an end. Thank you.
Thank you, Ms. Matier. Any rebuttal?
Yes, Your Honor. May I inquire as to how much time I have left?
I
Yeah,
have
I've got
4 minutes on my
same
clock.
I'm sorry, what was that?
4 minutes. We both have 4 minutes.
4 minutes. Great. Thank you. May I proceed, Your Honor?
You may.
Opposing counsel just told you that we have brought you no evidence that the defendant was the cause of Lou Donaldson's death. But remember, members of the jury, you have the circumstances, the circumstantial evidence that the defendant is the cause. She had the perfect disposal set up right in her backyard. Cats, carnivorous cats, and a meat grinder, which she admits, or which she guesses is big enough to fit an adult male. It is more likely than not that the defendant is the cause of Lou Donaldson's death because she confessed to it. She confessed that she fed Lou Donaldson to the cats. Remember Exotic Bob's testimony. Defense counsel also stated that the defendant has never been a suspect in the police investigation into Lou Donaldson's disappearance. Make no mistake, the defendant is the sister of a sheriff's deputy in the same department investigating Lou Donaldson's death. The fact that the police have not arrested her, have not listed her as a suspect, have not released any information or evidence into their investigation, have not even closed that investigation, that is not an accident. The defense claims that Chris Renard is unbiased because he doesn't work for anybody party to this case. But the only nuggets of information that Chris Renard got from his contact in the Pioneer Police Department, the only nuggets he got help the defendant. That is not a coincidence. The defendant is the sister of a sheriff's deputy. The defense counsel just told you that Cam Donaldson is here for money. But if Cam Donaldson were to choose, he would pay any amount of money to have his father back here with him. But he can't make that choice because the defendant took it away from him. She caused the death of Lou Donaldson. Members of the jury, the police did not do their job in this case. The prosecutor didn't do their job. Chris Renard didn't do his job. So it is your turn to do justice. Find the defendant liable and award Lou Donaldson's family $10 million in damages. Thank you.
Thank you, Ms. Riegelsberger. The case is now submitted to the jury, and we will dismiss the jury for deliberations. Actually, we're going to keep the jury, and I'm going to dismiss the advocates so we can do our score sheets. So very well done by all of you. Congratulations.
Thank you so much.
I enjoyed it.
Y'all have a nice night.
So, all right. So for our jurors, if you'll come back on screen,